Our chief guests onto the dais. Is away here. Ladies and gentlemen, a big round of applause. May we now request C.A. Pannaraj S, Chairman, SARC of ICI, to welcome the gathering.
Good evening all. First of all, my pranams to Akshay Kumar sir and Bhupati sir, who are my teachers, and also Balakrishnan sir, who was president during my student days. Also, a very warm welcome to proud teacher from SARC, also now the Supreme Court advocate, Arvind sir. A very, very warm welcome to you. Thank you for accepting our invitation for this G. NARAYANASWAMY Memorial Lecture. Also, welcome sir. Subramanian sir. A very warm welcome to you. And also Sir Mohan sir and our secretary Mr. Arun and my colleagues in the council, Revati and all the invitees here, attendees here, a very warm welcome to you. We are all eager to hear Arvind sir, and also very warm welcome part chairman of SARC, including Ravi sir and others here, and several council members, Sri Priya Madam and R.K. sir. A very, very warm welcome to you all, and we will start the proceedings of the day. Thank you very much.
Thank you, sir. May we now request C.A.S. Mohan, Vice President of the Society of Auditors, to introduce our chief guests of the day.
Good evening. Sri Arvind Datta does not require an introduction, but it is customary that the Chief Guest is introduced. So, Sri Arvind Datta is a senior advocate in India whose practice is focused mainly on constitutional commercial taxation, regulatory laws, mainly before the Supreme Court of India. He started his legal career in 1980 as an advocate in the chambers of N. Natarajan, senior advocate, and Mrs. Ramani Natarajan. He later joined the office of Subraya, Padmanabhan and Ramamani, where he practiced income tax and central customs laws. Mr. Datar set up his independent practice in 1984, appeared primarily before the Madras High Court on its original appellate and writ sites. During this time, he was predominantly engaged in matters relating to income tax and central excise customs and company law. He was designated as a senior advocate by the Madras High Court in the year 2000. Mr. Datta routinely appears before the Supreme Court of India in matters relating to constitutional, corporate, commercial tax and regulatory laws. He also appears as amicus curiae appointed by the Supreme Court and various high courts to assist the court in matters on questions of constitutional and taxation law. He also appears as counsel before various high courts and apart from that statutory tribunals and in bilateral investment treaty matters and international commercial arbitration. Here it is before you are in the tax.
Subbu, don't want an introduction. Subbu is a good friend of all of us. Okay.
Sandra Sasal needs no introduction. Let's move on to the core event of the day, the most awaited lecture by Sri Arvind Datta, Senior Advocate, Supreme Court. Dice is all yours, sir. I'm sorry. Mr. President, may we now request C.A.G. Subramanian, sir, to give the presidential address.
Introduce Sunatana Vandavana.
Good evening, everyone.
in our anxiety to listen to the learned Mr. Arvind Datar, the presidential address was taken to be delivered. It's a great privilege conferred on me to preside over the first memorial lecture in the name of a doyen in the profession, Sri G. Narayanaswamy. I'm grateful for this opportunity, but I'm here because of the offer made by Sri G. Srikanth and the order given by Sri R. Sivakumar. Talking about a close friend, talking about a friend who is much older in age and experience and intellect is a very, very onerous task. My association with Sri GN started in the year 1978. Soon after, I started practicing in Chennai, thanks to a few friends, including Mr. P.Datar, who introduced me to Sri GN in 1978. Most of you will not be aware that both of us were colleagues in contesting elections. He was contesting for the Central Council and I was contesting for the Regional Council. His was an outstanding success, mine was a miserable loss. But then that gave a bondage between the two of us. Maybe the feeling that I should in some form get a better recognition amongst the professionals compelled him to take me as an associate in many professional activities. The number of opportunities that he provided for attending seminars, conferences and workshops all over the country is countless. And I must place here on record that he was such a person that thousands of the trainees in his office were provided similar opportunities throughout their training period. That friendship grew. We were not only professional colleagues, we were friends and foes. It turned out to be that he treated me as an advisor. And at a particular point of time, I became his conscience keeper. Many of the senior members in the profession, probably Mr. Balakrishnan will vouch for that, used to inquire with me about his personal programs as though only with my consent he was accepting any of those assignments. He was so close to me that some of the common friends said, "You have the advantage of the initial. After Mr. G. Narayanaswamy, Mr. G. Sitaraman, Mr. G. Natarajan, you are G. Subramanian, probably you are the youngest of the brothers." And that even led people to think that on his demise, I will get a substantial part of his wealth. But they did not know that even before his demise, I had inherited quite a number of his qualities and his traits. Such was the closeness. And in addition to that, we were together in many organizations. Notable among them was the Hindustan Chamber of Commerce. I had been a member for over 35 years. But then, during his term as the president and a few years after that, he made sure that I also rose in the echelons of Hindustan Chamber of Commerce, and he had the satisfaction of seeing me as a president of the Hindustan Chamber of Commerce in the year 2006-2007. We were together in YMIA. I would say we struggled together, but then the greatest satisfaction that he gained was keeping the organization intact, preserving the properties and safeguarding the values that Dr. Annie Besant stood for. There are so many other organizations, including the Rajaji Center for Public Affairs and the Mahalakshmi Temple and Kalyana Mandapam Association, rechristning as Mahalakshmi Welfare Association. In a few organizations, I became a successor by default. I owe a lot to him for the exposure that I got. The analytical skills, a deep sense of generosity towards fellow human beings. He would never allow anyone to suffer, even if it were to be because resulting in his own suffering. A very great attribute, and somebody who was simple, humble, and noble. And therefore we had a privilege of celebrating something called the Noble 90s in the year 2018. He was one of the 3 great noble 90s people of that time, and that was celebrated at the Dakshinamurthy Auditorium in PS Senior Secondary School. Mr. K.V.S. Gopalakrishnan is also here, who was party to that. There are so many things that we can talk about Mr. Narayanaswamy, but what I would mention here as the most notable is my disappointment with him. I was so closely associated with him, I also knew the background to his failure to become or to get elected as the Vice President of the Institute of Chartered Accountants of India. And he was so carefree in his approach. He said, if it doesn't come to me, so what? But then it was such a rude shock to people like me. But then God has his own way of compensation. In the year 1999, his younger brother, Mr. G. Sitaraman, who is here, got elected as the Vice President, the first and only candidate who was not present at the time of the elections. Mr. Narayanaswamy was such an avid race goer, so I have to refer here to a possible similarity. Those who are familiar with horse racing and betting will know that hundreds or thousands of people bet on individual horses, or 3 horses in a row, or 5 horses in a row, and the 5 horses in a row, it's called a jackpot ticket. Huge collections were being made or being made even now. And if on any one race day, if there was no one successfully nominating those 5 horses in those different 5 races, the jackpot gets carried over. And on the subsequent race date, the carried forward jackpot collection, as also that day's collection, is given to the or distributed to the winners on that day. The carried forward jackpot of Mr. Narayanaswamy was given to the lucky winner, Mr. G. Sitaraman. He was so attached to his family, he was so attached to all the people working for him. Hundreds of chartered accountants who have qualified from his office still remember his great qualities, still consider that they have learned so much from him. It is fitting that today we are celebrating his memory and his life by having this first memorial lecture. But then, in the fitness of things, who else could fit into the role of speaking on this momentous day? Mr. Arvind P.Datar. He is a friend for nearly 40 years. I was fortunate to be a colleague of his in the Nani Palkiwala Arbitration Center. He is also very generous-minded. That's why he used to recommend me as an arbitrator in the Madras High Court proceedings, and he was very generous in applauding and appreciating the kind of results that came out of such arbitration. He is a true follower of Nani Palkiwala, and the kind of noble services that he is associated with are again too many to be listed. It is our good fortune that we have Mr. Arvind Datar to deliver this memorial lecture, and along with each one of you, I am just awaiting with bated breath to listen to his brilliant lecture. I thank each one of you for a very patient hearing. Thank you.
That was an emotional presidential address, truly from the heart. It was a pleasure listening to you, sir, on the nostalgic memories of Sri G. Narayanaswamy, the wealth you treasure even today. A thoughtful way to begin the memorial lecture of the noble soul by his own younger brother. Over to you, sir.
Mr. Chairman, my colleagues in the dais, members of the family of late Sri G. Narayanaswamy, and my dear friends. When my dear friend Shivkumar called me and requested me to deliver the first memorial lecture in memory of Sri Narayanaswamy, it was a privilege and an honor to me. And I told him that I'll come at any time, just let it be a Friday. And he really agreed. GS also has been a dear friend. I think he's the only professional who quit the profession at 45. I used to keep joking with him that you can never retire, because professionals never retire, they keep going on and on. But he was one person who had the courage to leave the profession and devote himself to great service. When I paid floral tributes to Sri Narayanaswamy, his photograph was so lifelike that immediately several memories came to mind. I first had the opportunity to see him, of course he was much more senior to me, when I was Ramamani's junior. And they would often interact, and Mr. G. Narayanaswamy, Mr. Sitaram would also come to the Income Tax Appellate Tribunal on the 3rd floor here, and I would see them in various matters. I still remember the ready wit and the humor with which he conducted himself. At the same time, it was a dignified way of putting across things. I still remember Mr. Sitaraman writing Sri Ram Jayam Swami notebook from time to time in the tribunal. And I used to always wonder, why is he not reading an ITR? But anyway, so many pleasant memories. Mr. Narayanaswamy was very encouraging to me when I started my practice in 1984. He would always make it a point to invite me to speak on budget seminars. So very often I would speak on indirect taxes. And I would say that part of my initial success was due to the encouragement of people like Sri G. Narayanaswamy. Well, I never knew that he liked horse racing. So the interesting anecdote to me, I'm sure that you will be horrified to know that horse racing is now going to be subject to 28% GST on the gross amount. And I don't know how long the horse racing will continue in this country at this rate. Talking of jackpot, just a pleasant personal anecdote, a memory. I was in a boarding school, and one of my classmates was two brothers, Ishwar Singh and Magan Singh Jodha, whose father was a jockey, Prutu Singh Jodha. And I used to follow the horse racing quite regularly. And I still remember when I was studying in the Viya College, Ramanand Sagar, who was the producer of the Ramayana series, the jackpot had not been won for 3 or 4 weeks. And in 1972-73, he won the jackpot of 48 lakhs, which was a staggering amount in those days. So when you talk of horse racing, I remember that. Now, I must also thank Mr. Mohan for the introduction. In fact, recently someone told me, I was attending some function and somebody said that many chief guests don't require introduction, they require a conclusion. So I promise not to extend my time and try to say something interesting to all of you. Before I start my lecture, I must say that coming to the CA Institute, particularly SIRC, is always an emotional event for me. From 1981 to 1992, I was teaching in the institute. I still remember getting off the bus near the Rosewood apartment opposite the church, coming for the class. Sometimes I would come from the court, come for the class and go back. I had stalwarts like Mr. Bhupati, Mr. Upadhyay, who all were teaching with me. And I can honestly say that whatever tax I have knowledge of came when I taught the subject. And I always take youngsters that I was teaching mercantile law in the ICWA and in the company secretaries and teaching taxation here. And the best way to learn a subject is to teach it. And what I decided was, I said that I would teach without a note. So I would take extra trouble to study the whole subject. So I owe in the institute a very, very deep debt of gratitude, in particular, and to Sri Narayanaswamy. So it is also a very personal, emotional moment for me to be called upon to deliver the first memorial lecture. When we were discussing the, and before I forget, thank you GS for the very, very warm welcome, both reflecting upon the qualities of Mr. Narayanaswamy and us. As somebody said that these are the role models for us. They leave their, what we call traits, which we can emulate. Now coming to my lecture, when I was discussing the topic with Shivkumar, I thought of, instead of talking something on interpretation of a tax law, I thought I'll share my thoughts, which continuously bothers me. That is the importance of tax policy in a nation's future. Actually, it is exactly 48 hours since the Chandrayaan-3 landed on the moon. We still have the pleasant hangover of a spectacular achievement that Indian scientists did. I can still feel the pride and all of us must be feeling it, that that we can do it. And I can never forget the moment when the thing was landing. I still remember July 21st, 1969, when Neil Armstrong was getting off the thing. But this was also the equally moment that yes, we are the 4th country to land on the moon, to land on the south pole of the moon, and we have bridged the technical gap. As far as space and technology is concerned, we are a developed nation. But in reflecting upon it, we now have to work on bridging the gap in the economic development. While there is a sense of euphoria at what we have done, there is also a sense of responsibility, a sense of apprehension of what is still ahead of us. Today, unfortunately, there is a complete allergy to any kind of bad news. Everything in the paper is very wonderful, nice, GST collection shooting up, India is the center, Apple is coming to India, this is happening, that is happening. So, but let us not forget that let us not ignore the brutal facts which we have to consider. I'll just give you a few figures as to how far we are from what we can potentially achieve. If you take the latest fortune of August-September, they give the Fortune 500, as all of us know. In 2002, there were 9 Chinese companies in the Fortune 500. In 2023, there are 135 Chinese companies in Fortune 500. There are 136 American companies. So if you put China and the US together, it's 135 plus 136. 271 out of 500 companies just come from 2 countries. 3 out of the first 6 companies in the Fortune 500 are Chinese. And when I just did some maths, it is very surprising, I mean, it's very startling that the turnover of the first 6 top companies in the world is equal to our GDP. So it also shows that there is no point saying we are the 4th largest economy. We have to see what is our GDP, per capita GDP. Our per capita GDP is slipped below that of Bangladesh. There are certain pointers which you have to note. One is the gap between us. China is a 15 trillion economy, we are a 3 trillion economy with the same population. See, we are 1.4 billion, they are 1.35 billion, but they are at 15 trillion, US is at 21 trillion, and we are at 3 trillion. Keep the gap in mind. The second thing is, per capita GDP is a better yardstick than the total GDP. The third thing is, which again worries me a lot, is the slipping down of the manufacturing sector from 16.5% of the GDP to 13%. Manufacturing is going down year by year, which is an alarming thing. In fact, when I was in some committee meeting, they said, our GST collections has gone up by some 8%. I said, have you ever found out how many new factories have been set up? How many new employment has been created? It's very easy to get beguiled and set in the lull of complacency by seeing these figures and ignoring the harsh reality. Now, the other point I must mention is why I say India can easily bridge the gap. If you just see the figures, there's a wonderful article in Business Line on the India-China deficit. Now, the deficit between India and China for 22-23 is $83 billion. If you take the sectoral, the first 2 digits of the harmonized code give the sectors, and the 4 digits give the subsectors. Out of $83 billion, 60% of the deficit comes from just 3 industries: electrical and electronics, pharmaceuticals, and organic chemicals. And my feeling is, why can't we make the same thing? Why do we have to import it? My mother, I bought her a blood pressure monitor, it's made in Vietnam. We recently replaced our refrigerator, Samsung, is made in Thailand. So like this, I used to always bother. My habit is when I buy a product, I first see where it is made. Why can't we make it? I remember on one flight, which I fly back with Rajendra Kumar, and we were sitting together, and he told me a startling story. He said, India imports 1,100 crores of balloons from China. Rubber balloons, happy birthday and so on, which you use there. Those balloons are imported. And I always wondered that, isn't it paradoxical that we have to come? Then I asked the question, what makes a person leave India and go to Vietnam, go to Bangladesh, go to... And one of the theses I've got is, it's our tax policy. Now, I was watching an interesting video the other day on health, and the speaker said that you say anything else, I mean, whatever you say, ultimately health depends on 3 factors: your diet, your exercise, and your sleep. It's like a tripod on which your good health rests. If any one is not proper, if you ignore sleep, you will fail. If you ignore diet, you will fail. So all 3 must be there. Otherwise, the system will not be, your health will not be stable. And I thought to myself that for a country, the 3 important pillars would be your clear long-term policy, your regulatory laws, and according to me, the most important, your tax laws. These are the 3 important pillars. And today's topic is only confined to tax laws. I have a lot to say on the regulatory laws, whether it is factory law and so on. One point I'll just leave with you is that on clear vision, perhaps my best example is what, if you get time, go to the YouTube and watch John F. Kennedy's moon speech, where he says in 1961, he says, because by that time, you will all remember, Yuri Gagarin had overtaken America and he had circled the earth, and the Russian program was much more advanced than him. It was also a political kind of a snub that communism is much better than capitalism and so on. But speaking at a university function, President Kennedy makes a moon speech and says that we will send a man to the moon and bring him back by the end of the decade. So in 61 he says, by 1970 we will do it, send a man to the moon and bring him back. Mind you, I was watching another video which said that today the software in my iPad can handle more complexity than what was available in the Saturn V rocket. It did not include so many electronics. But just to do all the mathematical calculations to put a man in the moon. But look at it, galvanized the whole nation. So if we have a clear vision that we are going to be 5 trillion by 2030, then all the factors must go towards that. In terms of regulatory framework, I've always analyzed it. It's substantially the responsibility of the state governments, because all the state laws deal with starting a business, your licensing, your permit, the clearances, etc., all the state. But once the business starts, the real problem which we have to sort out is tax policy. And I would suggest that if we have to become a really strong nation, see, there's no point talking of soft power and saying we are the center of yoga and so on, that's all okay. But unless you have solid economic growth or manufacturing base, you're not going to go anywhere as far as we are concerned. Now, what would be the things which should address for tax policies? And I would flag 3 points for you. The first point I would say is, you must have business-friendly laws. And what do I mean by that? If you see the Economist of 3 issues earlier, now today there is a big race for making semiconductor chips. Everything is in Taiwan. The Taiwan semiconductor, TSCI is the world's leader in semiconductor chips. So everybody is trying to set up semiconductor factories. Germany has announced $11 billion euro subsidy to Intel for setting up a chip factory. $11 billion euros. Now suppose I told you that the German tax law says that this 11 billion euros will be subject to a 40% tax and knocked off by the Germans. What would you do? You would laugh at it. But that is exactly what is 2 subsection 24 clause 16 of the Income Tax Act. Any subsidy, any drawback, any incentive, whether in cash or not, is deemed to be your income. Now we have challenged this provision. It is coming on 11 September in the Bombay High Court. A company has been set up in Maharashtra. It's a large company. And the Maharashtra government had a scheme that if you set up a factory in a backward area, provided you invest 1,500 crores, you guarantee employment to 750 people. If you satisfy these parameters, then we will give certain incentives. There will be a reduction in Provident Fund. There will be a reduction in ESI. There will be a sales tax refund scheme, VAT refund scheme. And there will be also the 50% waiver of stamp duty. Now the industry is set up and now they've got a notice saying that everything including the 50% stamp duty is deemed to be the income and it is sought to be taxed. Now this is one example of a completely unfriendly, senseless business law. I mean, what is the point in you giving an incentive to set up an industry? It's basically to meet your capex. And if you say that capex is going to be, which is going to be funded, is going to be your income and subject to 30-40% tax, that is completely unfriendly. You take the other problem which we are facing, now it's going to come up in the Supreme Court. Secondment. I don't know how many of you know this problem, which is a huge problem for foreign companies, secondment. In this northern operating case, the Supreme Court, what happened was there is a company in India. Foreign employees were deputed to India. They were working in India, but doing the work of the foreign company. The Service Tax Department said that the Indian company had to reimburse that salary. So the Supreme Court said that this is manpower service and subject to tax. For the life of me, I don't know how it can be manpower service, but that's the law of the Supreme Court. And Article 1, what is binding on us. But the important point was there the foreign employee came to India, worked for the foreign company, and that was held to be taxable as service tax. Now what the department has done is, they have now sent notices to all the companies. Every company, say Maruti, if Maruti has 52% shares held by Suzuki. Now I've been, in some meetings with government officials, I've said, look, any foreign company which has more than 50% investment would like to keep its own man as the MD. Right? Obviously, I'm not going to keep some Arvind Datar or Subramaniam there as an MD. I'm going to make my own Japanese Nakamichi or somebody as the MD. Now, if you say that when the Japanese person works here, he continues to be an employee of the parent company for social security reasons. That's a common thing. Now, if the Indian company reimburses the salary, it is said that Japan is doing manpower supply service to India. And they have reopened all the assessment from 1/7/2017. There was a proposal by the Japanese chamber to say that, look, please waive the interest and penalty, but not being done. Now everybody is completely bewildered. They said no other country does this. I was appearing for a large aircraft company. They have 50 to 90 employees at any point of time are in India because they supplied large number of aircraft to India, Indian Air Force and so on. They are facing the same problem. Now they said we had a meeting in Delhi, they said we are dealing with 91 countries, and no other country says that when my person comes here for 50 days, 60 days to do service, sophisticated service, I have to pay service tax. Now, if these are the laws, you're never going to succeed. So the government has to see that this is the kind of law you're making. Please try to benchmark. No other country does it. Why are you doing it? The third example I'll give is the investment treaty arbitrations. We had the investment treaty arbitration, and Article 5 says that it's a very simple clause. It's called the FET clause, fair and equitable treatment. So India signs a treaty with UK and says that Indian investors will be treated fairly, equitably in the UK. FET, fair and equitable treatment. Vice versa, when Britain puts investment in India, its investment will be treated fairly and equitably. That's all, there's nothing more than that. The Vodafone retrospective amendment triggered a number of arbitrations. Everybody said that you made us invest. Our investment has been cleared by the FIPT. Everything is done now. Suddenly you retrospectively amend the law and say I have to pay tax. And the arbitration, the main arbitration for Kane, went against India. They cancelled all the treaties with various countries. Now, many clients, whom we deal with, they say, look, if you're going to invest in a country and if it's got an investment treaty arbitration clause, we know that we can go to The Hague or we can go to Paris and sort out our case, because we don't fully trust the Indian tax system, because we would like to have this. And these treaties are with everybody else. So when we spoke at a seminar, we had this meeting with the senior additional secretaries and so on. They said that these judgments invariably go against developing countries. This is a wonderful article by a scholar who traced 33 international arbitral awards on taxation. 17 have gone in favor of the state and 16 in favor of the SSE. So to say that these arbitrations are against the is not correct. Now what is the consequence? We have now got a new treaty, model treaty, which has removed taxation. So any tax dispute cannot be arbitrated. That's the main headache for everybody. The other point is what is called the exhaustion of remedies clause. In international law, there is something called exhaustion of remedies. Now look at the paradox. Exhaustion of remedies says, before you go for international arbitration, you must exhaust all your remedies in India. So I must go up to the Supreme Court, and then if I am satisfied, I am unhappy, then I go to arbitration. Now anybody will tell you that if once the Supreme Court has declared the law, what is the use of the arbitration? So Indian Model Treaty, introduced in 2016, has been signed by two countries, one of which is Belize. If you know what is Belize, Belize population is 3 lakhs. Now what I am submitting is, if you want to be an international player, if you want to attract huge amount of FDI, what is the harm in saying, yes, I have got an FET clause, Article 5 will say, all your investments will be treated fairly equitably. Please come to India. That is a big problem which the government is refusing. They say, no, the law will go against us. Why do you think that way? Why don't you think, if you want to be a leading economy, think like a leading economy. Germany doesn't shy away from FET. Japan doesn't shy away from FET. Their laws are equitable and fair. And lastly, I'll mention the authority for advanced ruling. Now, I'm just talking in terms of attracting FDI. I remember when I was a junior, when Justice Ranganathan was the chairperson, the Said Shah Qadri was the chairperson. What orders we got? It was truly a spectacular, full faith tribunal. People would come in. In fact, I say the watershed moment was 1991 when a lot of foreign investment started coming, and then we had the AR. What has happened now? You got an AR consisting of 3 commissioners. So I tell people that say don't challenge it, go to the new AR, it's called a BAR now. You have got no tension because you are going to lose. Then take it to the High Court. So, but the foreign investor is not very happy about it. He says, if I am going to invest and I want to know what is the tax liability, I want an independent arbitral tribunal to decide. They will be domestic. This AR is nothing but a domestic arbitral tribunal where you put your case, I am going to invest this, will it be liable or not? So these are the things where business-friendly laws are extremely important. The second suggestion I would make is to abolish this revenue targets. I have been pleading with this again and again and again. And right since the time I was a junior Ramamani, I have seen January onwards 147 galore, all sorts of reassessments, and one day I proposed to write a book, collect all the interesting cases I've argued on 147, on the kind of absurdity which you have in a. I got a case where a 10A benefit of 4,400 crores was denied. Assessment reopened. What is the ground? The officer has written to the International Taxation Department and said, how is this person transmitting the software? Because he said we have got lease lines. Lease line means a dedicated lease line. We send the software, we get the thing, we pay on an annual basis. Where is the lease line? We said lease line is with BSNL. It ends at what's called a cable landing station. It ends at the cable landing station, and from there AT&T takes it over. Because, and when it comes from foreign, AT&T will be at the cable landing station. There the Indian network will take over. The denial was, you have not exported because your cable is only up to Bombay cable landing station. 4,400 crores, we moved a writ petition, we are asked to deposit 440 crores. I told the judge that's absurd. No, he said, we see you deposit 440 crores. Now that company was completely shocked. That general counsel came from New York and he was completely stunned. He said, what is happening? I've exported. India is a place where I've got a number of back offices. All my international accounting is done here. I have a cost plus 10% model. And you say that I have not exported because my cable doesn't go. So if I have got exported Venezuela, unless my cable goes to Venezuela, it's not an export. Other case I'll give of Nokia, which I'll tell you. Because see, these are the things, unless we rectify these things, we are not going to go anywhere. Nokia came. Nokia exported, they were set up in Sriperumbudur. One big success story of Mr. Arvind Shuri was he was able to persuade Nokia to set up its first factory outside Finland, not in China but in India. One fine day we get a show cause notice. By that time they had exported phones to 81 countries, made in Tamil Nadu, made in India, to 81 countries. And the total exports for 6 years was 24,000, let's say 25,000 crores. They had got export awards, monies had come from foreign exchange, all the bank statements had been filed. One sales tax officer asked for some particulars of all the exports done for 6 years. Revenue target. So they gave a sample of 500 invoices and they said they're totally 1 lakh plus bills of entries for various things. And therefore I can't give it. Since you're not supplying the records, I will treat all the exports as interstate sales and levy tax at 12%. Now the story doesn't end there. We go to the High Court, we get a thing. High Court says you go back and explain it, but I will not ask them to enforce the demand. Now look at the next part 2, like the serial. When we go back, the disallowance comes down to 1,000 crores. What is 1,400 crores? They said your bill of export, the airway bill, takes London, but the phones have been delivered in Manchester or Birmingham, therefore I have not accepted as an export. The airway bill does not mention the destination. So this is the kind of thing which happens on revenue targets which we have to address. And I've been telling people that, you see, my friend Anand was telling me that 97% tax is collected through TDS and advance tax. All this 3% which you're fighting is just for this 3%. Now what is the great purpose in having these revenue targets which are not going to help anybody at all, and ultimately the refund is going to come. And what is very unfortunate is, in fact today when I was appearing before Justice Shagdar, he said I'm getting grounds of appeal saying the department is putting an affidavit, we have not accepted the Supreme Court judgment because they have filed a review. Can you imagine? We have not accepted the High Court judgment. I've got cases where the refund has been denied by disallowing an item which has been confirmed by the Supreme Court. So in the course of revenue targets, this is the huge point which you have to take care of. Now, third and last point is, I've always, in law they say something called judicial impact assessment. If you want to make a law, at least in the UK and the US, there is a body which analyzes what will be the impact of this change in law. Suppose you want to introduce RERA, Real Estate Regulatory Authority. What are the potential disputes that are going to arise? Do you have the infrastructure to deal with the disputes? The whole problem is you make a law and do not see the impact of that law. In the case of RERA, you had RERA. There was no RERA tribunal, no RERA authority in UP. In Noida alone, there are 61,000 petitions. How do you deal with it? 138. Entire criminal system is clogged because of 138. So there's been a repeated thing in legal circles that look, when any law is made, first think of the impact. And I would say do the same thing for tax. Take the case of 28% online gaming. I must put a disclaimer, I put in the Karnataka High Court for some of them. They all said it is gambling. Once you put money and you're going to win or lose, it is gambling. And they demanded the staggering amounts of money from online gaming companies from, as usual, everything goes from 1/7/2017. From the birth of the good and simple tax, demand will be made. We found, I was reading a Supreme Court judgment and I saw there was a Public Gambling Act which was put in Urdu by that Nizam, by the late Nizam. So I said, if he has put some Public Gambling Act, there must be some British law on this point earlier. So we did research, my interns did some research, and we found that there is a Public Gambling Act of 1867 which has not been repealed. All the Victorian law, this law has not been repealed. And section 14 of that law says, any game of skill, even if played for money, is not a wager. So rummy is a game of skill, bridge is a game of skill, Scrabble is a game of skill, it is not gambling. So on that basis, the Karnataka High Court quashed the notice, and I said, this is parliamentary law, you can't go against the parliamentary law. At least you must say, GST must say, notwithstanding anything contained in the Public Gaming Act. No. Now what is the next thing? They simply put in Schedule 3, online gaming is a taxable service, finished. They can do that. Now we've been pleading with them that don't put 28% tax on the gross amount. I don't know if I've never played an online game. I've always baffled at how much of spare time people have, but anyway, the whole industry survives on that. In fact, if you read today's business line, the expected investment in online gaming for the next 3 years is £4 billion, 4 billion euros. More than 1,20,000 people are involved in online gaming. It's a huge, and it's not just gambling. There are people who are playing games of skill like Scrabble. So there's so many games. There are word puzzles and so on and so forth, and you play for money. Now what we told the government was, if I put 100 rupees in the game, 10 rupees is the platform fee. The online company takes 10 rupees. 90 rupees is shared as by the winners. We are paying 18% on, when the gaming companies are paying 18% on 10 rupees. What the law now says is, it will be 28% on the entire 100. So if 28% goes on the entire 100, I gave a mathematical calculation article I wrote in Indian Express that the third prize winner will get less than his 100 rupee bet. So if the third prize, on third prize there is no winner, there are only losers. So the government then, I don't know because of that article or whatever, the same day the finance minister said we'll have a relook. Once again they met and said no, we will have 28% on the gross amount, but we'll review it in 1st November. How many companies will survive by then? And what happens is, many foreign investors tell me, look, the whole thing is the uncertainty. Another thing which I mentioned about business-friendly laws, one thing which bothers many investors who come to me is the reopening of 10 years. If you see the amendment, first it was 3 years. For 10 years, if it's represented by an asset, undisclosed income asset like 153A. Now for books of accounts you can make for 10 years. But today a person from Germany comes and says, Mr. Datar, I've invested money. I am not very sure what will happen till 2032, 33. And he's right. So, when you see the tax impact, kindly see what is the consequence of what you're doing. Now you put 28%, and I've been discussing this in various seminars. I don't know if you agree with me, but my view is that most of us think only in silos. Income tax will think of income tax collection, GST will think of GST collection, custom will think of customs collection. This target has to be met. I say, why don't you take holistically? If you take online gaming, for example, let me continue that example. 1,10,000 people are directly employed. They are people who are programmers, who are tech specialists and so on. Now, the total tax collected from online gaming is 1,700 crores, 1656, let's say 1,700 crores. Astonishingly, the government secretary said that by raising 28%, we are going to collect 17,000 crores. Now to collect 17,000 crores at 28%, they should be people must game for 1 lakh. Now, who will put money in India in gaming? If I'm going to pay 28% on gross, I'm not going to win at all. Now, I would say, when you talk of tax impact assessment, now this is an industry. It is giving me 1700 crores of direct taxes. It is generating employment for 1 lakh people. Have you made a sample study? What is the income generated for these 1 lakh? These 1 lakh people are going to buy goods, they are going to buy services, their children are going to be educated. The indirect benefit is going to spin off. Have you thought of the indirect collections which will arise if so many people are employed? The other major problem we are facing now is, look at the, in GST, lease is deemed to be a service. Now, with my limited brain, I don't know how, if I lease my house, my office, under section 105 of the Transfer of Property Act, lease is a transfer of interest in the property. All of us know that. Sale is a transfer of property under section 54. Lease is a transfer of interest in the property. How is that a service? But Parliament has said it is a service. Alright. Now, one problem we're facing is, many industrial development corporations have given 99-year lease. Alright. Now, it so happens that after 30 years, 40 years, a company wants to either give up the lease and give it to somebody else, or it may have got 20 acres, it may not need 20 acres. Land was plentiful in those days. Today, it may say, alright, I'll give a lease, the remaining 45 years I'll give to somebody else. Now, a major problem which is coming is, since lease is a service, and just imagine 10 acres in Bombay, that lease will be some 1,000 crores or some staggering amount. 18% is the GST. 13% is the stamp duty, 18% is the GST. Now, if you do the maths, it is much cheaper to put up a factory in Vietnam and import the goods to India. If you do the calculation. Now, why are you doing this? And we have tried our best in the GST Council, because there is a Madras High Court judgment, other High Court judgment, where they said that if the lease is for a longer period, then it is akin to a sale. The stamp duty is as if you are selling the property. They take the market value of the land and levy stamp duty. Now, if you take that market value and put 18%, it just becomes uneconomical. This matter also is coming up in court, and I don't know what is going to happen. So, these are the 3 suggestions I made. And finally, I will just conclude. You see, it's so paradoxical. We have got the capacity to put a man on the vehicle on the moon, but yet we don't focus enough on what needs to be done economically. Now, I think that there is an imperative need to make the Indian soil fertile for investment. Why do you need a production-linked investment? Why can't India itself be the investment? As a nation, we should be an attractive place to invest. And believe me, this PLI is not going to work beyond a certain point. You may have Foxconn putting Apple phones and Samsung phones and so on. How much of employment it is generated? And also, don't forget, it's made in India is mostly assembled in India. What we really want is manufactured in India. The components must be made in India. Then only it's a real make in India. And I'm not saying just like that. I know in this so-called PLI scheme, if medical equipment, a sophisticated medical equipment is assembled in China or in Germany, but because it is made in India, the person told me it takes 34 hours to dismantle they assemble the whole machine, they test it, then because we have to do make in India, it is disassembled in the country, brought to India, and again assembled in 29 hours. So 35 plus 29 hours is to make a product, break it up, bring it to India and assemble India, and then they say PLI scheme. Now, this is okay initially, at least you can say some value addition is there, some people are being employed, some wealth is being generated. But this is not the long-term view that I look forward to India when I say tax policy must go from revenue maximization to growth maximization. And I've also myself, through a person called Mr. Santosh Pai, he has undertaken a study, I can share with whoever you want. He has done a study of comparing the tax system of China, Vietnam, Thailand and India. Now, if India has to be an attractive destination, we have to market India, right? If you want to sell TVs, you must sell the TV which the customer wants. Today the foreign FDI person is our customer. We have to make what he wants. And I keep telling myself, that we are not saying I'm going to make a TV. It is 42.36 inches. It is in a triangular shape. If you want to buy it, you buy it. You first see what the FDI people want. I have known personal friends of mine who have shifted from India to Vietnam in the garment sector. They've gone to Bangladesh because they say it's extremely difficult to work in India kind of tax laws we have and also the regulatory laws. So one way is to benchmark what are the incentives offered in tax by Vietnam, Burma, Thailand, etc. Can we offer the same thing? Why should Samsung make a refrigerator in Thailand? Why should balloons, as Mr. Rajendra said, be made in China? Why can't they be made in India? The reason is, it is just not worth the effort. It's not, the tax policy is too dangerous, and it is time for us to rectify it. And I will just conclude by saying that the tax policy is the third tripod. It is today the most worrisome tripod. I am doing work for a very large automotive manufacturer, and the matter is in the Supreme Court. The General Counsel came from the parent company. They have made huge demands on customs. And you see, our system, they open everything for 5 years. And they use the word suppression, willful misstatement. That creates a tremendous problem because they have to report that to the stock exchange there. So he's very upset. He said, why are you alleging this? You may not agree with my interpretation. And he told me a very important point. He said, sir, 2% of my sales is in India, but 95% of my litigation is in India. And that I checked with other people, they say it's somewhat similar. So finally, ladies and gentlemen, I'll conclude by saying that what needs to happen is that tax should always be treated as a byproduct. It should never be the aim. As a professional, the first thing my senior told me, Mr. Natarajan told me, he says that always remember, money is a byproduct in your profession. You deliver outstanding service, money will come. But if you focus on money, you will be ruined. In the same way, if we focus on growth, if we focus on a high economy, and what makes me sad is 60% of the imports are electrical goods, electronic goods, organic chemicals and pharmaceuticals. This is not some rocket science which we cannot do. And that's what is most saddening as far as I am concerned, and I feel very strongly about it. So I just conclude by saying that as long as we focus, if we focus on growth, then taxes, focus on more growth, we'll have more taxes as a byproduct and more important, more employment. Today 125 million jobs are needed. The announcement was by 2022 we'll create 125 million jobs. Still a long way to go. But on the other hand, if we focus only on revenue as we are doing, then we will have very little growth or not adequate growth. We will become uncompetitive as a country, and worst of all, we will not generate employment. Ladies and gentlemen, somebody said that if we continue to do what we are doing, we will remain where we are. The essence of human improvement is to depart from your old self and embrace the new self. As somebody said, what is important is to make the familiar unfamiliar and to make the unfamiliar familiar. We have to abandon the status quo, which we are used to, and go into a new area where the system of taxation is full of trust, it is business friendly, and it promotes growth. Thank you.
Thank you so much, sir. A memorable memorial lecture. The first memorial lecture of Shri Ji couldn't have been better. A holistic view of the nation's economy, the clear vision path to see Mother India as a developed nation. The three strong pillars, tripod, to be collectively taken care, being the clear long tax policy, long-term policy, regulatory laws and tax laws. Business-friendly laws to be brought in, more manufacturing industries, being the true make in India manufacturing, not assembling in India, to improve GDP per capita, to experience the true growth and attract FDI to raise the status of our economy. Removing revenue targets, bringing in a sea change there, looking at tax laws to be the byproduct of growth, economy and employment. Long-term vision of any law which is introduced, the Secret Law of Public Gaming Act, a holistic view on the investment, employment opportunities, the revenue and the growth impact, to bring in the true essence of ease of doing business, a complete 360-degree view on the growth and impact from micro to macro will bring in the true growth by being an attractive place of investments. Embrace change and embrace growth. Let us all pray that the Mother India really grows well to be a very, very developed economy. Thank you so much for the wonderful lecture. Ladies and gentlemen, a big round of applause, please. May we now request Shri G. Sitaraman to present a memento to Shri Datar.
I request Mr. G. Sitaraman to hand over a small autobiography of Sri Narayanaswamy to Subhashini, the computer. G. Sitaraman will give. Yeah. Back to Subhashini.
May we now request CAAV Arun, the Secretary of the SRC, to propose the order of thanks. Sorry? Questions? Okay. So the audience have few questions. To GSL or Tata?
Yeah, I don't.
Okay.
Hello, yes.
In my view, certain problems are also created by the courts, particularly in the case of the service tax which you are talking about, and also the various other judgments we have seen. So, what is the way?
You will mention the Deloitte case.
Particularly charitable trusts.
Yeah.
We do not know, including the Institute of Chartered Accountants of India is caught, and also NFRA, which is another issue which is bothering all the chartered accountants. So, what is the way out? You see, the regulators or the judiciary, see, they go, sometimes I would even say, with full respect, that they go berserk. They don't follow any rule of precedence. So, what do? And we also have some judges who are, not tuned with the present day circumstances. And, we have seen certain judges specifically, taking a different path than whatever the precedents are. PMLA is another law, which is bothering a lot of people, and including chartered accountants are now caught. So, what is the way out? See, the laws are enacted, fine, by the bureaucracy, but the courts are not helping the people. What is the view on that?
See, one thing, 2 points I mentioned. One thing has happened is like take this secondment issue, where you start levying 18% service tax on the salary paid to the employee here. Now, when they requested that, you see, before the Supreme Court judgment came in a different context, the tribunal held that when the employee comes to India and works, there is no manpower supply, he is working for the Indian company, and therefore he should not be taxed. So everybody went on that basis. Now Supreme Court judgment comes, they want to start levying interest and penalty from 1/7/2017. Now, in all the companies it is running into a few thousand crores. Now, this completely thing. Now, I thought the government could say that, look, that northern operating system was in a different situation, therefore that judgment will not apply. But they take the easy way out and say, no, I'm getting more revenue, I will take it. But it has created so much of uneasiness. Now, I'll tell you a matter, because apart from the institute, I've been appearing for the institute I appeared for the institute in the two subsections being chartered Ahmedabad Urban Development. The stand of the government was so shocking. One was, leave alone the institute for the time being. Maharashtra Industrial Development Corporation, Ahmedabad Urban Development Authority. Now take in Maharashtra, for example, which I was not appearing for them, I gave a illustrative example to the court. They had given a 99-year lease of a property in Bombay for 3,500 crores. It's a 99-year lease. That amount was taken as a lease and it was used to build certain infrastructures in Bombay, particularly the Warsaw area. Now, one of the most unimaginable, ununderstandable amendments is this 2 subsection 15 proviso, saying that if you are a charitable trust and your other income is more than 20% of your donation, then it is taxable. I don't understand how, because your donations can never be the majority. Your donation can be small. Like say Lizzat Papad. Suppose I am making Lizzat Papad and selling the papad and using it for charity. Donations may be less. I got a marriage hall, I give it for rent, I get a rental, I run a school. All that is it. The argument of the union was, and mind you, MIDC, look at the point as you said, luckily we had a bench which at least dropped it for all the development corporations. We said that in my own case, the tribunal has held, they had given an earlier 99-year lease. They said such lease is a capital revenue, it can't be taxed, it doesn't affect 2 subsection 15. The officer ignores the binding tribunal decision, relies on a Jammu and Kashmir tribunal and disallows it. He is not accountable. How does he do it? Justice Ranganathan Very said this will be judicial anarchy, you should follow discipline, but are you holding him to account? Are you stopping his salary, stopping his increment? Nothing. So one thing is, it is just as I said, complete focus on make more revenue this year, that's all. And that is the biggest problem which I feel more than anything else. Now to answer your question, very often the courts also with great respect don't understand the commercial consequences of what we are doing. Right in the bank nationalization case, Justice Shah put a very important point. He said you must have the object and effect test. Not only in parliament, but I also mentioned the judgments. The court must understand what is the effect of what they decide. Now in this Deloitte case, ILFS, 140 subsection 5 says that if a particular auditor is doing something illegally, he can be suspended, etc. 5 years. Now they use the word auditor and it says auditor includes firm. I tried my best to argue that if you take Deloitte for example, there are 170 partners, 80 are in tax and let's say 90 are in audit. Now just because 2 partners are involved in ILFS, assuming it's wrong, I mean we had managed to say it was not incorrect, you can't castigate the entire firm for 5 years. I said please interpret 140 subsection 5 with the explanation purpose, in a purposive manner. The intention is to take 2 partners. I said today we are in the era of LLP. We don't have the old section 11 of the Companies Act where anything money, organization more than 20 partners is illegal association. LLP now permits everything. And as you say, I quoted to the court section 7, 8 and 27 of the LLP Act which says what is done by 2 partners will not taint the whole firm. That's not been discussed at all.
And how can they do the retired partner?
Exactly. And what the Bombay High Court said was, it says that if a partner does something, you can remove the auditor. Now, our argument was that we have retired in 2016 because under 139, I think the 139 is the section where you can be for 2 terms of 5 years each. Right? 139 and 140 is removed. 139, I said, I finished in 2016, happened in 2018. You put me under NAFRA, do whatever you want under the Act. You can't remove a person who has been removed. It's like sentencing a person to death who already died. It's absurd. But then what we said was, okay, ultimately if you hold, we pleaded that, look, let it not taint the whole firm, number one, and let it not affect the past auditors. We are not going scot-free. but yet the judgment went against. This is a practical problem. Very often the court sometimes feel it's, there are some courts which they feel that some revenue loss will be some great national catastrophe. But you should see the point, and I've been telling people that every time they say 400 crores are involved. Just Rumapal once told the AG, and she threw the file and said, I'll dismiss it. If ever you can tell me the amount. We decide on principles. And the point is, look at the consequence of Deloitte, look at the consequence of KUDA. When your CA Institute, luckily we succeeded. Argument that they are doing business, you are running classes, you should have seen the arguments of the Union of India against the CA Institute. They are doing business, they are running classes, they are making money, look at the surplus they have got. And what did the court finally say? That yes, you are covered by 215, but if you sell your prospectus of 10 rupees for 50 rupees, you are profiting. Now you said nominal amount. How do you do it? Now I can't now, this thing is cost 8 paise. If I make 1 rupee, I am making 10 times the amount. Am I profiteering? Complete. Now I am saying, and I try to tell the Supreme Court just for 1 minute. I said Harvard has a corpus of $5 billion. Donations to Harvard is tax free. MIT has $6 or $7 billion. People don't bother. You become great research centers when you don't bother about this thing. You are constantly thinking. The Supreme Court also. You can profit, but you cannot profit here. Up to 15% is okay. Why? Supreme Court says so. Anything above Supreme Court, you are profiteering. And I keep saying to myself, I said that nobody should make profit except advocates, arbitrators, and so on. What we do is not profiteering. Why? Let that man own what he wants. Let them. It's a market economy. If somebody is willing to pay, let him pay. What's your problem? So this is another problem which we have, especially in charitable trust, and now it's become absolutely unmanageable. And there is unfortunately no exit. If you have one Samadhan scheme for charitable trust, I'm sure 90% trust will walk out and say, I don't want 12, I don't want 12, I don't want anything, I just want to live in peace.
That's a tendency.
Sir?
That's a tendency which is happening.
What?
Nobody would like to do charity. Nobody would like to get associated with charitable.
Yes. No, I'll tell you one example. What a sad case I lost. The Satya Sai Baba Trust, Puttaparthi, they were funding a hospital. Sorry, just 2 minutes, sir. Just holding up you. They were funding a hospital in remote Gujarat. It was a 250-bed multi-specialty hospital with 5 ICUs, 18 operation theatres, state-of-the-art thing, where people had not seen. They used to go to Ahmedabad and Baroda for treatment. They could get treatment in near their village. Under 35, one section, there was a program where your scheme can be approved by a special committee. Now, Chief Justice Lahoti was appointed the chairperson of the committee with some 4 committee members. That committee approved this hospital. They got the approval in 2013-14 and it was going to continue till 18-19, 5 years. In 2016, the amendment came after 3 years saying we are disallowing the deduction. I literally begged the court. I said, look, I've got the approval, I've got donations, my hospital is half finished. Apply Vatika townships. You say that this cancellation won't affect 2 clearances given in the past. I've been given a clearance saying for 5 years I can collect tax-free donations. And I said, it's approved by a retired Chief Justice. I have to file my accounts. I have to demonstrate that I put up the hospital. My plans are approved. I got clearance from medical council. Everything I got. Please don't do it. They said, no, there is no equity about a tax, and they cancelled it. What happened? Instead of 5 ICUs, only 3 ICUs. Nobody gave donation. So, look, as I said, what is the consequence of what you are doing? What is the effect of the law? You may say literal interpretation, but if it's a charitable hospital, take a better view. But anyway, that case also we lost.
Sir, I have one question.
Yeah.
GST and corporate guarantee given by holding company to subsidiary company comes under import of service. How far it is correct?
It's not correct. What to do? There so many things are not correct.
So many holding companies
I know.
given corporate
I
guarantee.
know.
Lakhs of rupees coming. And valuation, what is the position valuation? How to value?
That's a problem. You got one guarantee. You take works contract. Works contract service.
Performance guarantee.
Huh?
Performance guarantee.
Performance guarantee.
The performance guarantee. I'm saying there are many anomalies. You take works contract. It's an inverted duty structure because cement is 28%. Very often your duty is more. But they say works contract will not give you credit on service retrospectively. What we argued was you made the amendment in 2021. All of us have given the bids. before 2021, thinking that we'll get credit of input service also. That's how the tender was floated. Now suddenly you say I won't get credit on input service. What happens? So we gave full costing that the Bombay so-and-so corridor project will go by 110 crores, this will go by 80 crores. All the calculation has been done. They said, I said at least make it prospective. They said no. They said that if we interfere with, we are crossing the judicial boundary, therefore we will not interfere. Now what is the impact? Now again there is a spin-off. Many agreements say that if there is a change in law, you can claim the higher tax. Now the department says a judgment is not a change in law. Change in law only is parliamentary law. So about 40 arbitrations have started. What is change in law?
And directors also giving guarantee. Directors also giving guarantee.
Yes.
That is also subject to GST.
Yes.
But RBI says that directors are not allowed to take any consideration. RBI is saying that no consideration is allowed to take.
Yes.
But GST says you have to pay GST on
Notional value.
Notional value.
Under Rule 31, yeah, there is no consideration. Yeah. Tell me.
115 TD.
150 TD, yes. Again, trust. You have to pay tax on the current market value. Absolutely. No, there are so many stories. I think I should just write. It shows what kind of.
In the recent amendment, one trust given donation to another trust, similar trust, 50% is taxable.
Yes.
That is
Yes.
also
I think it's better to say that there will be no charitable trust in India. Once and for all, close the chapter instead of having 11, 12, 13, 33. Then if you take a donation in 1 year, you must give the names of all your relatives. You see that form 10B and so on.
Nobody can do it.
It's very difficult to find.
Thank you, sir. Over to CA.
Thank
They
you.
released yesterday only, 10B. Asked us to file before 30th. How it was?
Good luck to you.
Yeah, thank you, sir. Chairman of SIRC and past president of SIRC, Sitaraman sir, Balakrishnan sir, Bhupati sir, and senior members and the program organizer Ashok Kumar sir. So this warm good evening to one and all present here. So every time the Ashok Kumar sir organize any program, it is a knowledge treat to those who are all attending the program. Thank you for organizing such a wonderful program. And in spite of his busy schedule, he is accepting our invitation and presenting the lecture. Sir, thank you. One advice, that is, the money is a byproduct of our profession. It's okay for our youngsters, especially for the youngsters. So,
You also.
Yeah. Yes, sir.
You also.
So thank you for the good suggestion, sir. And I thank Prayer Shang, Anirudh and MC Subhashini madam and all the office bearers, those who are all supporting, and my council colleague Revanthi madam and Society of Auditors Morgan sir and GS Subramaniam sir. Thank you one and all present again. Thank you.
Let us all rise up for the national anthem.
मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे शुभ आशीष मांगे गाहे तब जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Thank you so much.